So the Supreme Court has ruled that divisions in the electoral body, that is IEBC, witnessed in the wake of the August 9th election were not sufficient to warrant a nullification, pointing an accusing finger at the 4 dissenting commissioners, saying they had not provided evidence to prove their claims that the integrity of the polls had been affected by the cracks. The 7-judge bench, which overall concluded that the polls body had presided over a free, fair, credible and verifiable election, however, declared Regulation 87(3) in the Elections Act of 2011 as amended in 2017 as contrary and inconsistent with the Constitution. Chemutai Goin has more.
The Independent Electoral and Boundaries Commission came under sharp criticism by petitioners challenging the declaration of William Ruto as president-elect, saying the emergence of divisions within the commission after 4 commissioners steered clear of the commission's chair announcement was testament that the integrity of the election was not guaranteed. But as the Supreme Court judges rendered their verdict, they turned against the petitioners.
Are we to nullify an election on the basis of a last-minute boardroom rupture, the details of which remain scanty and contradictory between the chairperson of the commission and some of its members? This we cannot do. Clearly, the current dysfunctionality at the commission impugns the state of its corporate governance, but does not affect the conduct of the 2022 election. In view of the foregoing, we are satisfied that notwithstanding the divisions apparent between the chairperson and the 4 commissioners, IEBC carried out the verification, tallying and declaration of results in accordance with Article 138(3)(c) and 10 of the Constitution.
The bench alluding to dishonesty by the 4 dissenting commissioners in their claim that they were not involved in the final verification and tallying of the presidential results, saying they had received evidence of the commissioners reading out the results transmitted from the constituency tallying centres.
They have not explained why they participated in a verification process when they knew that it was opaque up until the last minute. Indeed, at the Serena Hotel press briefing, the 4 commissioners acknowledged that thus far the entire election had been managed efficiently and credibly. The chairperson on his part did not make matters any better by maintaining a stoic silence, even as things appeared to be falling apart. All this, in our view, points to a serious malaise in the governance of an institution entrusted with one of the monumental tasks of midwifing our democracy.
Besides Odinga, the 4 commissioners in their affidavits sought a nullification of the election on the basis that the election process had not been free and fair.
Apart from their 11th hour denunciation of the verification and tallying process and their averments regarding the conduct of the chairperson, the 4 commissioners have not placed before this court any information or documents showing that the elections were either compromised or that the result would have substantially differed from that declared by the chairperson.
And in what seemed to be a slap on the wrist for IEBC Chairman Wafula Chebukati was a determination of the interpretation of Article 138(3)(c) and 138(10) of the Constitution on the role of the Commission and its chairperson in verification of results, saying the chairman cannot act alone and that in the case of the August 15th declaration, there was proof that the 4 commissioners had participated in the process.
Chairperson cannot arrogate to himself the power to verify and tally the results of a presidential election to the exclusion of other members of the commission.
The judges, however, condemning Election Regulation 87(3).
Consequently, to the extent that Regulation 87(3) of the Elections General Regulation purports to vest the power of verifying and tallying presidential election results as received at the National Tallying Center solely on the chairperson to the exclusion of other members of the Commission, the same is contrary to and inconsistent with the provisions of the Constitution.
With the August 9th election having exposed weaknesses in the polls body IEBC, and though the 7-judge bench partially absolved the commission from some of the misfiring on polling day, the full judgment that will be delivered in the next 21 days is now set to address some of the constitutional issues that affect the operations of